Trump's citizenship case. A century-old argument revived the Supreme Court is now considering a case, Trump v. Barbara, that rehashes a deeply flawed legal argument regarding birthright citizenship. The core of the dispute centers on whether children born in the U.S. to non-citizens or undocumented immigrants are automatically granted citizenship under the 14th Amendment. While seemingly novel, this legal strategy isn't new. It's a direct revival of racist, 19th-century efforts to exclude specific groups from full American rights. The historical roots of exclusion President Trump's administration is arguing that the 14th Amendment Citizenship Clause should not apply to children of temporary or undocumented immigrants. This position echoes arguments made in the late 1800s by white supremacist lawyers, most notably Alexander Porter Morse, who sought to deny citizenship to Chinese Americans. Morse proposed that only children of permanent residents should be citizens, a concept aimed at systematically excluding immigrant communities perceived as not capable of assimilation. The argument was rooted in the racist idea that some groups were incapable of integrating into American society, a notion that even Morse himself later abandoned, admitting his proposed test was unworkable in practice. Despite its failure then, Trump's legal team is now actively citing Morse's writings as justification for their policy. Why this matters now, the revival of these historical arguments, is not simply an academic exercise. It has real-world consequences for millions of people born in the U.S. to non-citizen parents. If successful, the administration's interpretation would effectively strip citizenship from a large segment of the population, creating a class of stateless individuals subject to deportation. The 14th Amendment's subject to jurisdiction clause, which allows for exceptions to birthright citizenship, has historically been limited to diplomats and Native Americans. Expanding this exception to include undocumented immigrants or temporary visitors would fundamentally alter the meaning of citizenship itself. The court's precedent, the legal foundation for birthright citizenship, is well established in United States v. Wong Kim Ark, 1898. This landmark ruling affirmed that all persons born in the U.S. are citizens, with narrow exceptions that do not apply to the current case. Yet, Trump's lawyers are attempting to circumvent this precedent by leaning on outdated and discredited theories. The fact that even the original proponent of this argument Morse conceded its impracticality underscores its weakness. The administration is essentially asking the court to revive a failed idea that was rejected by its own intellectual architect over a century ago. Ultimately, Trump's attempt to redefine citizenship through a century-old, racially motivated argument is unlikely to succeed. The Constitution's language, historical precedent, and practical realities all favor the existing interpretation of birthright citizenship. The case serves as a stark reminder that seemingly new policies are often rooted in old prejudices.